standing Committee of the Senate on Codes has come to order. I am Senator Mike Consolio, Chair of the committee. To my right is Senator Dan Squadron, the ranking member of the Codes Committee.
And your left.
You're always on my left, but today you're on my right. Very pleased that Senator Krueger, Senator Exar, and Senator Savino are here with us. Please call the first bill, print number 819A by Senator Little.
Senator, this is an act to amend the penal law in relation to providing that an elementary or secondary school student shall be capable of consenting to sexual conduct with a school employee.
Motion to report, negative votes, bills reported. 1524 by Senator Klein.
Senator, this is an act to amend the penal law in relation to including certain documents, insurance certificates, in the forgery statute.
Motion to report, negative votes, bills reported. 2083 by Senator Flanagan.
Senator, this is an act to amend the penal law in relation to restitution for a municipality.
Motion to report, negative votes, bills reported. 2720 by Senator Griffo.
Senator, this is an act to amend the executive law and to provide a denial of parole when an individual is found to be a danger, an imminent threat to society, and require that person to serve their full determinate or their full indeterminate sentence.
Senator Squadron.
A couple of questions on this. We have discussed this bill before, just briefly. What other instances are there extrajudicial processes for permanent detention or incarceration?
I don't know what you mean by permanent. The statutes, the sentencing guidelines set forth certain time frames for conviction of certain felonies, and the executive law, the correction law, modify those in a discretionary way through the functioning of the parole board. Under certain circumstances, those sentences can be lessened and people released before the end of their max out date.
Right, this is the other side. This is the indeterminate side on the beyond the length of the sentence imposed by the government. So, what other instances are there extrajudicial ability to create indeterminate sentences beyond what was traditionally imposed?
There's civil confinement.
Sorry?
There is civil confinement.
Post-release supervision.
Okay, so I'm asking what examples there are. So civil confinement, how does that work?
Post-release supervision.
How does civil confinement work?
There's a proceeding whereby the defendant or the inmate is determined to be a danger of reoffend, sex offense, always, and he's confined beyond his term in a civil confinement facility, which is actually maintained by GOTS, as I recall.
Right, but is by statute not the same as being incarcerated, and there's judicial remedy that's civil confinement they can be pursued, correct?
What this bill is proposing to do is just eliminate the mandatory conditional release. I guess on both minimums would be within the term of sentences, and on determined sentences, which still is a CRD, which means that the inmate is released if he has not lost any good time short of the maximum.
So in the determinate setting, you would be eligible for that early release after serving 6/7 of your sentence. Senator Griffo chooses in this legislation to allow the board and to take certain factors into consideration and let them serve the entire 7/7. And in the indeterminate sense, 2/3 of your sentence you're eligible for release. In this bill, they would have to serve 3/3.
Let me just ask one final question. Would this only be for folks sentenced in the future, or would it be for folks serving sentences currently?
measure takes effect immediately.
So it would have, thank you, so it would have the impact, just to conclude here, so instead of the impact of changing the length of sentences that have been imposed judicially by changing the statutory role of conditional release and the court of parole plays. And that, on its face, I think should make us all very concerned. Parole courts have very specific, narrow roles. The judge has determined sentences based on an expectation of what is happening with conditional release, what is happening with good time and full time. And to change that, it empowers the parole boards, undermines the judges, and undermines the sentences that have been meted out. So I'm certainly on this, I can intervene on this, but I think we should just be a lot more careful about extrajudicial power of the criminal justice system.
Thank you, Senator. We have been joined by Senators O'Mara, Boyle, and Penapinto. Thank you very much, gentlemen, for your participation. Dan, I think your original line of questioning dealt with post incarceration. The fact of the matter is, or post-sentence. The fact of the matter is that this applies during that time when a person is eligible for parole under the normal circumstances of the sentence, has time left on their sentence. And it was just a story in today's New York Post, I don't know if you saw it, about a 1980 very heinous rape murder where someone was up for parole. They were given parole under some very questionable circumstances, and that, according to the article. And that pattern is exactly what this measure is trying to prevent. An individual who commits a very heinous crime and with clear and convincing evidence is a danger if that person is a danger to society or she was released from prison without serving his or her maximum term. So for that reason, I'm, without any further questions, calling the debate closed on this issue. Motion to report measure 2720 is before us. Negative votes. Thank you.
Negative.
Those moved. Senators Krueger and to the negative.
Without recommendation.
Senator Penapinto without recommendation. The measure passes. 2819 by Senator Lodson.
Senator, this is a bill to an act to amend the penal law in relation to non-support of children.
Motion to report. Negative votes. Bills reported. 3199 by Senator Ravella.
Senator, this is an act to amend the penal law in relation to including a machete within the definition of a deadly weapon in the penal law.
Motion to report.
Question.
Senator Krueger.
Thank you. So I've actually voted for this bill in the past, but now I'm led to believe that machetes are used actually as tools in certain kinds of outdoor businesses, including farming, including some types of landscape work. So I just want a clarification. Obviously, we don't want a machete used as an instrument of violence and attacking anyone, but is there, under this law, then people who use machetes as part of their professional businesses would also no longer be able to use them?
Senator, yes, the way the sponsor defines this, he drops this definition into a section of the penal law that defines deadly weapons. And then there's other sections of the penal law that prescribe crimes with those deadly weapons. And one of them is criminal possession of a weapon in the fourth degree, which requires an unlawful intent. So when he or she would use that weapon unlawfully against another, that would be committing a crime. So someone that is using it to clear a field or clear brush would not be, by mere possession, committing a crime.
So they would be allowed to own them and continue to use them?
Yes.
And so when it's defined as a weapon, I guess that I'm not clear what this law does. I mean, obviously if I chop the senator's head off with a machete, whether we, sorry, who's your hero, sorry. I can chop some. if I chop Senator Squadron's head
It's
off.
always me.
Well, I got in trouble already, so I'm trying for you now. If I chop some unknown senator's head off with a machete, you would find me guilty of murder and a violent crime. Would the fact that now we define machete as a weapon increase the penalty some way?
Well, if I may just give a different example.
Okay.
If you were to make a threat with that machete.
Yes.
Then, in the example you gave, of course, there would be a more serious offense there. But
Right.
If you were to make a threat with it, or intimidate someone with it, or harass someone, then the more serious offense under this would be the possession of it, and you're using it unlawfully because your intent is expressed through those threats or other things that are not as extreme as an assault. So that's the case where it would be.
But again, if I'm a landscaper who uses a machete to, the example I was given was chop down weeds along a pond bank or a river bank, that would not be using it as a weapon, and therefore I could go out and buy one and use it as part of my business, and it wouldn't be a problem.
That is correct.
That's correct. Thank you.
Motion's on 3199 by Senator Avella.
We have
Any
another
opposed?
question.
I don't
Have
want
time
to.
to do so.
Yeah, I mean, just thinking about the scenario that Senator Kruger.
Because I didn't offer to cut your head off.
That's fine. Don't chop my head off. I mean, what if somebody's not using the machete in a threatening manner? They're just in possession. You have a landscaper that gets an altercation with somebody. Is the crime, is it elevated at that point if it's only a physical altercation and you're in possession of the machete? Can you answer that?
Obviously, there's going to be things that there's a fact-by-fact, case-by-case analysis, but the bright line examples are the easy ones to answer. The closer we get to some factual question, it's going to be up to the police whether they charge it or whether the district attorney believes that there's sufficient evidence to show an intent to use unlawful. As any crime.
Okay, we've been joined by Senator Golden. Any other questions, Senator?
Yes. Oh, sorry.
Let me answer my question.
Senator Kruger, who's in a very violent mood today.
Who's actually shopping? Well, we know more machete hypotheticals. But in the penal law, section 26501, criminal possession of a weapon in the fourth degree, my counsel points out that it would be a misdemeanor, even just owning it, even if I was using it for a non-violent purpose, a professional weed whacking purpose, so to speak.
I don't believe that's correct, because it says in section 2 that, well, yeah, if you look at the bill, section 10 of the penal law is modified. Okay? So then in section 2, it makes reference to what would be a deadly instrument or weapon, which picks up that modification in section 10 of the penal law. And then it continues in section 2 to say, to use the same unlawfully against another. So my interpretation of this is consistent with what I previously discussed.
Your interpretation is that it would be under subdivision 1, not subdivision 2. Because you're adding it to the language of subdivision 1. But if that was, if the intent of the draft, if the intent of the sponsor is just limited to
Subdivision 1 makes
subdivision 2,
no reference to deadly weapon.
but you're adding it to the definition, but I understand. But again, I think the sponsor's intent is just to make it addressed to subdivision 2. But who knows?
I thought the sponsor's intent was to make it so that exactly the scenario that the senator is expressing is protects a person and yet proscribes against it. Otherwise, it would be problematic. I agree with you.
Mr. Chair, could you ask the councils to do follow-up with the sponsor after the meeting? Because I don't object to this bill if it in fact is as being described by your council. But I might have a problem if we were somehow unintentionally outlawing the use of machetes for legal activities where I'm not sure there are alternative items to be used by landscapers and farmers, etc.
we'd be glad to ask the councils to meet prior to this measure going before either the Rules Committee or directly to the floor. Motion to report is 3199 by Senator Bella. Motion to report, negative votes. Without recommendation. Without recommendation, Senator Krueger, Senator Squadron. Senator Squadron withdraws his.
I had no.
In favor.
I mean, look at the list.
We've had,
I know it's passed.
3365A by Senator Gold.
Senator, this is an act of in law in relation to intentional physical injuries to a police officer.
Motion to report 3365A is before Senator Squadron.
Thank you. And we've discussed this bill in prior years. I think there are two questions, two outstanding questions about the bill. One is in prior years, council claimed that the idea of the perception regarding such police officer's involvement in previous arrest of such person was not language pulled out of thin air, but has a background in aggravated harassment. We have taken the year to define such statute in aggravated harassment. And so the aggravated harassment statute that council points to suggests that this idea of believing a belief on the part of the assailant in order to create the crime reads as follows. Because of a belief, this is the second part of 240.30. Because of a belief perception regarding such person's race, color, national origin, ancestry, gender, religion, religious practice, age, disability, or sexual orientation, regardless of whether the belief or perception is correct. It's essentially the list of categories of the human rights law and aggravated harassment, essentially in a hate crime type situation. I think the question here that I would ask council is, are we on solid ground having similar perceptions regarding a different class, which is such police officer's involvement in previous arrest of such person, in terms of how that would be proven out through the trial process?
Well, if we have good evidence on a case, we're on solid ground. So, it would be like any other case. The evidence would be evaluated by the police and the prosecutor, and if there were indication that first there was probable cause to believe that the arrest would be made, and second, if they believed that there was evidence beyond a reasonable doubt of this belief or perception, I would think that they would choose to push something like that to its trial.
Here's the issue, that when we talk about hate crime statutes, actually take quite a lot of precedent, quite a lot of time to define how you prove a belief perception about somebody else's status, A, and then B, how you prove the idea of due to. The fact. Sorry, let me just interrupt. So the question is whether we're kind of starting from scratch here with something that'll actually be very, very hard to prosecute. I understand the idea behind this. The idea is very important and makes sense, which is to sort of a retributive act based on a belief that a law enforcement officer, police officer, or a prosecutor for that matter, in this case a police officer, has somehow wronged you by doing their job. Protecting against that makes a lot of sense. But creating an entirely new, very hard to convict violation without, that's going to require endless litigation to actually figure out what we mean, doesn't seem like the best way to get there. And that's my concern. That the existing statute that's used as a model doesn't apply itself very well.
Well, if I can, to the chair, one of the purposes for this, and we've seen it happen several times, is I put somebody away myself for murder, and that person had gotten out. He's standing in the same gas station as my wife and children with, as I'm retired. And he looked at me, grabbed hold of the guy he was with, he pointed to me, came at me, I took him to get out. I had to leave the gas station. I didn't know I was unarmed. So this is to protect officers. There's an intent here for this crime, and if you have that intent, then this should be prosecuted as a second degree.
Okay. And I actually don't disagree with that. But I think the question is whether the intent that the sponsor described, and I'm very comfortable, it seems to be a specific kind of crime that should be considered more seriously than the average crime, than the average assault. whether as drafted, it can be made use of. And so, I'm going to go without rec for that reason, because, you know, again, we were only able to find this one aggravated harassment that really depended on essentially protected classes. And I worry about that being effective to, as an amendment.
If I can supplement my response to
Yeah.
last year, I probably left out the hate crime statute as well.
Well, which I was talking about, so.
Which also addresses.
But again, we're talking about sort of protected class with a whole legal architecture around what it means to be a protected class, and then applying it into individuals who should be protected, these officers who have done their job and should not risk assault for people that have done their job with, but don't have the whole legal architecture around their class, around the definition of who they are. And so I really worry about this from the perspective of being prosecutable without endless follow-up appeals and, you know, needing to build a whole new legal regime around this definition and an intent on this definition. Whereas, I mean, you could go to just a simpler intent language, might be a cleaner way to do it. So I'm going without rec for that reason, but if I can be convinced this is the best way to do this, then I'll be in favor of it.
Thank you, Senator. 3365A by Senator Golden. Motion has been made to report the measure. Negative votes. Bill is reported.
Without rec for me as well.
Without rec for Senator Krueger. 3806 by Senator DeZolio.
Senator, this is a action of the penal law in relation to cemetery desecration.
Motion reported. Negative votes. Senator Krueger.
I didn't know, and I really don't remain no, but let me just double check. This makes all desecration of the cemetery a Class C felony. Does not separate, it removes the separation of damage above and below a certain dollar figure.
It creates two classes, a first degree crime and a second degree crime, a E felony and a D felony, and it takes the concept of value for the damage out of the calculus.
So I thought this bill repeals current crimes in the second degree. And then adds a new provision, commits cemetery desecration in the second degree, and has been previously convicted, so it's the second time, and then it's a Class D felony, is that correct?
Right, that's a bump up for.
And so the $250 doesn't matter? Right.
No.
So if I'm stupid twice, regardless of the dollar value of the crime, it ends up being a Class D felony?
If you're previously convicted of that prior felony, yes.
And I think that people who end up desecrating cemeteries are more likely to be stupid and perhaps drunk young people, and I don't really see wanting to throw them in jail for this. I'll be a no vote. Thank you.
Motion is on measure 3806.
Very briefly. Isn't there, but there are still misdemeanors, I believe, available for the sort of situations that we're talking about. Is that correct?
Yes, and they can always be charged with an attempt.
And there aren't any specific existing misdemeanors around behavior cemeteries. I believe there are.
The cemetery desecration in the second degree, there's aggravated cemetery desecration, first degree and second degree. There's multiple.
All of which are misdemeanors.
No, there's.
But some of which are misdemeanors. Yes. Thank you. Okay,
Thank you, Senator Squatter. Motion report 3806. Negative votes. Bill is reported. 3822A by Senator Mendita.
Senator, this is a act of the criminal procedure law in relation to adjusting the jurisdiction for organized retail theft crimes.
Motion reported. Negative votes. Bill is reported. 4625A by Senator Alonso.
Senator, this is an act amendment of the criminal procedure law and executive law in relation to requiring interested parties, in addition to family members, to give a victim impact statement to the parole board.
Motion report. Negative votes. Bill is reported. 5871 by Senator Parker, who is here with us today.
Senator, this is a act to amend the penal law in relation to establishing a new crime of false pretense.
Motion to report. Senator Splavin.
I'd like to point out that this bill is on pursuant to Rule 8, 3E, which I appreciate the sponsor, and that forward to further bills pursuant to that rule for any consideration in the coming weeks. So thank you for Senator Barker for bringing that motion, and thank you to the chair for being on the agenda. Pursuant to that.
Motion to report, negative votes, bills report. Thank you very, very much. Start.